Jocelynne, it's lovely to see you again, and thank you very much for joining us today on our special 50s Women, our CEDAWinLAW special.
Oh, yes. Good afternoon, Ian. It's lovely to talk with you too. Yeah.
The Commission on the Status of Women takes place in New York next month, followed by a Women's Parliament at the Guildhall in Cambridge, over which you will preside. The theme for both is access to justice, mediation, and the ratified CEDAW Treaty. What deeds, not words, will women and girls draw from these momentous events following Harriet Harman's challenge to Sir Keir Starmer's government?
Well, the Commission on the Status of Women, as you say, taking place next month. It's in New York, and there are several events in which I'm involved with colleagues. One of them is on women's legal literacy. And one of the difficulties that arises for women is that women are less likely to be attuned to the justice system and to know the ins and outs than men. And that's because up until 1929, not even 100 years ago, women were considered non-persons by the courts in this country, as well as in Canada, Australia, United States, Aotearoa, New Zealand. And therefore, because we were considered to be non-persons, we were really written out of ensuring that we could get access to justice, and that the rule of law, which is that no one is above the law and everybody's treated equally, didn't apply to women because we certainly weren't treated equally. So this is one of the focuses on the Commission of the Status of Women, and will be, as you said, a focus at the Women's Parliament on the 20th of March, that's Friday, in Cambridge. And it's very interesting to think about this aspect, because often women have been led to believe that their signatures don't count. Therefore, they can be led into circumstances where they sign guarantees, for example, for husbands' or sons' loans. And when the loan is called in because the husband or son doesn't make the payments, then the woman becomes liable. And one of the things that's interesting here is that we've been through a period when women were not able to take out loans, bank loans, for example, and yet banks would always lock women in to the husband's or son's loans, because what banks know is, or finance providers, is that most women will do their level best to repay financial obligation, even if they're paying it off at £10 a week or £5 a week or £1 a week. They'll do what they can to pay it off. That's why banks have, despite being reluctant to lend women in their own right monies, they will lock them in to, as I've said, contracts, legal financial obligations relating to their husbands or partners or their sons. And another aspect of this, of course, comes in terms of the 1950s women pension debacle, if we can call it that. That's one name we might apply. I mean, I was very interested to note that one of the ministers involved in this, when the decision was made most recently, actually had the temerity to say that there would have been no point in sending letters to the 1950s women because they wouldn't have read them. Now, what's interesting about that proposition is that it's treating women as if they're stupid and they're fools, and that minister really needs to know that the last thing that women are fools or stupid. And surely the campaign for the 1950s women has brought that home to every single member of Parliament, every single minister, every single Secretary of State, that one thing that the 1950s women are not is stupid or compliant. The second aspect of it is that if that really was the thinking, and is the thinking, that women wouldn't have read letters, then what it indicates is that there is a serious obligation on the government to have ensured that women did know by some means other than a letter or on top of a letter. Now, what they've said is that the advertisements were sufficient. Well, first of all, that's a nonsense, because advertisements are certainly not read by everybody and are not seen by everybody, and they were in various newspapers that people don't necessarily buy. So that really doesn't wash. But coming back to the letters and to this absolute insult to 1950s women, the Minister or the Secretary of State, whoever it was who said that, has really put himself into a huge ditch. He's dug a hole for himself because, as I've said, if the knowledge and the thinking is and was that the 50s women are so stupid that they're not going to read a letter, then it's clear that the obligation of government to have informed women about this change becomes problematic. Not the obligation is certainly not problematic. The obligation is set in stone. But the way that they ought to have gone about advising women is something that they really needed to give proper consideration to. And it seems apparent that they didn't. So back to the access to justice, the Women's Parliament and the Commission on the Status of Women. These issues are absolutely germane to women's access to justice, to women's rights as human rights, to women being treated equally within the legal system and by government and by all authorities and institutions. What we are confronted with and why the major theme of the Commission on the Status of Women, the United Nations Commission on the Status of Women, in this 70th year of CSW, that's why women's access to justice is the top priority theme, because of this recognition that the notions like the rule of law, that everybody has a right to access to law in terms of knowing what the law is, in terms of being able to access the law if they have legal disputes, in terms of being able to be treated equally, and for if there is a power imbalance, for example, in mediation or conciliation, then that power imbalance to be recognised and to be dealt with in a way that redresses the balance.
Thank you, Jocelynne. And the 20th March would have been my mum's birthday.
Ah, right. Yeah, well, a very good date. Yes. And the Women's Parliament is really wonderful. I mean, we have a motion before the Parliament and all the women are able to speak for 5 minutes. So they are able to be attuned carefully and clearly to the subject matter and to make their points. And we have a great diversity in the Women's Parliament.
Sounds wonderful. Secretary McFadden's statement made on the 29th of January this year in the House of Commons laid itself open to judicial review. Would you enlighten our listeners as to why excluding CEDAWinLAW at least brought about the grounds for judicial review?
Right. Now, Ian, it depends what Secretary of State McFadden, what his actual decision was or was about, what the dimensions. Now, if the dimensions of that decision were solely based on the report from the Ombudsman and the 6 women whose circumstances were investigated and a part of that Ombudsman review, and the fact that the organisation known as WASPI is a company to which members belong by a payment. Now, if that's what the decision was focused on, first of all, it ignored the whole of the 3.5 million women that were impacted, because that group does not represent, and as they've acknowledged themselves, doesn't represent. They represent their members, their paid up members. And it opens itself to judicial review because, number one, it's ignored 3.5 million women who are not represented by that group. Number two, the Convention on the Elimination of All Forms of Discrimination Against Women was ratified by this country, the United Kingdom, 40 years ago. And in any decision-making of government that impacts on women, CEDAWinLAW should be taken into account. And there is absolutely no indication whatsoever that in making the decision that convention or treaty was taken into account. Therefore, government is in breach of its international law obligation under that treaty obligations, and it's opened itself to judiciary if we focus solely on that as the decision. If, however, we look further and say that what the minister was deciding, that none of the 3.5 million women impacted by the 1995 pension change and subsequent legislation that raised it to 66, if that's what the decision relates to, then again, CEDAW, the Convention on the Elimination of All Forms of Discrimination, was not taken into account, and that is a directly relevant consideration that has been ignored. That is therefore a judicial review point. Secondly, in the 8th Periodic Review of 2019 that was carried out by the CEDAW committee, the UN committee that looks into how governments are performing under CEDAW, in that review, what was said explicitly on this issue of pensions was this, and this is section 52, paragraph C. The committee is concerned that the increase in the state pension age for women from 60 to 66 following several legislative changes has affected the pensions entitlements of women born in the 1950s and is contributing to poverty, homelessness, and financial hardships among the affected women. The committee recommends that the state party, that is the United Kingdom, take effective measures to ensure that the increase in the state pension age from 60 to 66 does not have a discriminatory impact on women born in the 1950s. Now, when we look at that review and that statement by the UN committee in reviewing the United Kingdom's performance under the Convention on the Elimination of All Forms of Discrimination Against Women, number one, it's absolutely clear that the Secretary of State did not take that into account in his decision making. At least we can't see any indication of that. And number two, what that means is that the Secretary in that decision is not entitled to focus solely on the question of delay. First of all, if we do focus solely on the question of delay, the delay had a discriminatory impact on all the women affected because their economic position was impacted, which means when a decision is made by government, and decisions were being made by government all the time, the Department of Works and Pensions, when they made decisions as to when each woman would get her pension, there was a table and when the woman would get it. So that's actually a decision. And what had to be looked at was the discriminatory impact of the delay. And that hasn't been looked at. And the discrimination element is absolutely key and crucial to any decision making that the government makes in relation to the 1950s women and the pension age change. And as I've said, the latest decision by the Secretary of State pays no attention whatsoever, so far as I can see. Perhaps the Secretary of State might disabuse us of what appears from the decision-making process, but nothing about discrimination and the discriminatory impact. And that is absolutely crucial to what has happened here. First, the delay is properly considered from a discriminatory perspective. And secondly, every single decision that the Department of Works and Pensions made when it applied the table, or the tables, actually, there was one attached to the 1995 Act and then one attached, I think, to 2007 Act that impacted on the 1950s women. Every time a decision was made consistent with that schedule, then that's a decision of the department that needed to be looked at against the backdrop of CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. And a final point I'd like to make about this is that it appears that government is saying discrimination is not relevant. I don't think they've said it recently, but they've said it in the past or at different times. Discrimination is not relevant because there was a case that went before the High Court and the Court of Appeal said that discrimination did not apply, and that each time there was the court, in first instance the High Court, allowed every ground of that review to go to the High Court, the Court of Appeal, and then the Court of Appeal allowed every ground to go to the Supreme Court. Now, the Supreme Court knocked it out, not on those grounds, but on delay. Now, conventional law says, well, then because the Supreme Court didn't deal with those grounds, we revert to the Court of Appeal decision. I would actually challenge that. And I think it's something that really does need to be challenged through the legal system, because it actually, frankly, does not make sense. Because if every ground was allowed to go to the Supreme Court, and the Supreme Court does not consider those grounds, knocks it out on something else, then you can't actually just revert and say, oh, well, the Court of Appeal decision applies. I know that's the conventional legal thinking, but the way that law changes and the way that advances are made is when decisions that appear to be the conventional, the truth, the reality, etc., are challenged and can be overturned. And just to give an example of that, for centuries in this country, it was considered that rape in law was not a crime. And it took 1991 and a decision of the House of Lords to actually recognise that women are human beings who, whether they're married or not, have an entitlement not to be raped, whatever the relationship is that they have with the perpetrator. And so it took them ages to make that decision and to repeal effectively a legal authority, so-called, that had existed for centuries. So the fact that something's existed in law for centuries doesn't mean that you can't overturn it. You certainly can. But to come back to this point, in that judicial review, if they do want to keep saying, right, discrimination's been dealt with and therefore we don't have to deal with it again, they're absolutely wrong, because the Convention on the Elimination of All Forms of Discrimination was never addressed by the High Court or the Court of Appeal or the Supreme Court. What that case was based on was the ECHR, the European Convention on Human Rights. And so if we want to accept, okay, the Supreme Court didn't deal with those issues, those are the only issues the Supreme Court didn't deal with, because in terms of that case, because the only issues that were before it were the ECHR discrimination provisions, not CEDAW, not the Convention on the Elimination of All Forms of Discrimination Against Women. Therefore, CEDAW remains in issue and in operation, or it should be in operation, and the government has an absolute duty in international law to address it. And it's failed, and therefore it can be subject to judicial review, that decision.
Thank you, Jocelynne. CEDAWinLAW's call for mediation is based on the enforceable legal rights of all 3.5 million 1950s women, now enhanced by this fresh opportunity to mount a legal challenge. Why is mediation the route best suited to resolve matters in hand? Mediation,
and like conciliation, can be subject to criticism because of power imbalances between parties. When you're actually doing mediation and conciliation, you have to make sure that the party who is the mediator is 100% aware of differentials in power. And what we've got here are considerable differentials in power. That is, you've got the government on one side and you've got the 1950s women on the other. And the power imbalance lies with the government. So number one, you've got to have mediators who are absolutely 100% on the ball in relation to that. Secondly, the mediation is able to be taken up and ought to be taken up where there is a legal dispute that can be resolved through mediation. That's the number one principle within the legal system now that we have adopted alternative dispute resolution, ADR, which mediation is. And it's absolutely clear there is a dispute here. It's a legal dispute. And if it's to be resolved, it must be resolved by, number one, getting all the representatives of the 1950s women, the 3.5 million, together to sort out a proper way that the women's rights can be resolved. What is a plan that can go to government? And then you get the parties around the table, the representatives of the 3.5 million women. Unfortunately, some of them are dead now, but those women and their representatives of those women and the government on the other side to come to a sensible, workable, acceptable solution. And really, government in resisting this is, with the greatest of respect, not really, in my opinion, acting in the most sensible way. It's not acting also, sadly, in my opinion, as a government ought to. And this is not just the current government, but it's the government since 1995 really haven't actually come to grips with this question. And people who have been the Secretary of State, Work and Pensions, and Ministers of Works and Pensions have acknowledged this all along the line, that the right thing has not been done by the 1950s women. And so mediation is the way to go, because it is the way to resolve this without spending thousands and thousands and thousands of pounds on yet more legal activity through the courts, launching more legal actions through the courts. I think that what needs to happen is that a line needs to be drawn over the past, in the sense that it recognises that the decision-making of the past has been flawed, and then go forward on the basis that the government has a position to put, and it needs to work out a solution that it can consider is a fair one, that takes into account the discrimination that's impacted on the 1950s women, that's affected their economic status. And in that group, 1950s women, some have been affected and impacted far more than others. So they're not all the same. The redress to all of them is not going to be the same. And therefore, and then the 1950s women need to get their representatives round the table with the government, because that's the sensible way to resolve this matter. As I've said, the notion that court action has to be yet again launched or considered or put in action is simply more money that people are putting into the system, and the system is already held up. We're talking about ways to cut down the burden on the legal system, and this is one way to do it, and it's the way that the government can sensibly come to a resolution of this topic and be fair and be just to the 1950s women.
Thank you, Jocelynne. Now, I remember many years ago when I was at work, we had to do a mediation, and we were in one room, and the person that was obviously needed to benefit from us giving some ground, they were in another room, and somebody came in and kept going backward and forward, but it worked very well. I thought it was a really good way of doing things. It seemed to be very fair, very composed. You know, everybody was in separate rooms, and it could be, although I suppose in that situation you might be all together. And we gave fairly, and they came back and said, well, you know, we need a bit more. A really good way of sorting things out.
Yes, absolutely, Ian. When I said around the table, it could be physically around the same table. That's correct. That's one mediation process. Another one is, as you say, the parties are in separate rooms and the mediators go back and forth between the rooms and listen to what's being said by whoever the party is in the one room, and then takes that to the party in the other room, and then the party in the other room can talk through, how do we consider that proposition? Is there some way that we come back with our counter proposition? And absolutely, that method of mediation is one that is adopted, and it may well be the one that works in this case. And that's really for the parties and the mediator or the mediators to work out in terms of the mediation process. And it can work really well, because what parties generally do is go in with their ambit claim, the claim they put at the top, and then through this mediation process, you come to a point where both parties can agree that the outcome will be fair. And that's actually why you have to ensure that the party doing the mediation, the mediators, are cognizant of power imbalances, because one of the issues in mediation, as in conciliation, is that you don't want a situation where the party of lesser power agrees to something and then goes out and goes away and thinks, oh, that really isn't fair. I really shouldn't have agreed. And I've never done a mediation where that's happened to anything I've been involved in, but I have seen instances where, and I've dealt with instances where mediation agreements have been brought about, or conciliation agreements, and then the lesser party, is unhappy, because that's the problem with the power imbalance. Sometimes the lesser party goes along with what they think they have to go along with, and sometimes they see something as fair when it's categorically not fair, because they underestimate their value. And that's why women need to be really very careful in gaining support and advice when they're going into mediation, because they can actually be, treated in a way that makes them think it's fair when it's actually not. And that's one of the problems actually in the area of under the Equality Act, because under those discrimination acts in all countries operate in the way that we do here in the United Kingdom, there is conciliation as the first step. And in representing parties in conciliations, as in mediations, you have to be absolutely careful and scrupulous about ensuring that your client is not agreeing just because they don't value themselves properly. And the mediators have to be aware of that too. So we would need to build that awareness into the parties and the mediators.
Thank you, Jocelynne. And I want to hope that the Commission on the Status of Women in New York next month goes really well. It'd be really nice to hear back from that as well. And also, good luck with the Women's Parliament in Cambridge.
So much, Ian. Very much appreciated. And it was lovely talking with you today. Thank you.
And thank you for all you do for 1950s women.
Ditto to you, Ian. Thank you.
Thank you, Jocelynne.